Yeah, good idea.
Hi there, my name is Evan Feinberg. I'm the president of Generation Opportunity. I'm really excited to be joined here by our special guest, Senator Rand Paul. I'd first like to go ahead and introduce the folks that we've got in the Hangout right now. Across the country, we've got a number of watch parties going on of young folks that are particularly interested in our topic tonight, which is email privacy and civil liberties more broadly. So I'm excited to introduce folks from New Hampshire, Wisconsin, Ohio, and I think I got everyone there, and Iowa, I'm sorry. And I'm also joined by Corey Whalen of our team, a spokesperson for Generation Opportunity. Thanks for joining us, Corey. I'm particularly excited for someone who needs no introduction to you all, Senator Rand Paul, who's been a real leader on these issues in particular and many others. Thanks so much for being with us, Senator Paul.
I thought I got invited because I was like a Gen Xer or a Millennial. Is that why I was invited? Or?
Well, you're at least resonating with young Americans across the country.
Yeah,
so
in thought only. So, but not quite there. I'm a couple of I'm not even sure what generation I am, but a few removed from the Millennials. But I think we've got some things in common.
Fantastic. Well, I think one of those things that we have in common is our point of view and our approach to our privacy, in particular how it affects us when it comes to our emails, and then more broadly on some of these sort of civil liberties issues where we're concerned about government encroachment. So maybe you could just get us started by giving us an overview of where you see these issues, email privacy in particular, and then more broadly on civil liberties.
You know, technology has evolved so rapidly that I think we have so many, like a host of new questions we have to address. And some say, well, is the Constitution up to it? You know, it was written before there were telephones, before there was electricity. But some of the things are somewhat timeless and ought to protect us even in this day and age. The Constitution was very specific. You know, if you want to look at someone's records, if you want to look at their papers, you have to name them individually. You have to name what papers you want to look at. The police can't write the warrant. A judge has to write the warrant. Has to have probable cause. But where technology has sort of maybe confounded things a little bit is that the last time the Supreme Court looked at the issue of privacy and the issue of the Fourth Amendment really was back when we had dial-up phones, you know, with cords attached to them. Everything was a landline. There were no cell phones at all in the 1970s when the last time the Supreme Court really looked at these things and looked at the ability of whether the government can wiretap things. But to me, one of the most important aspects of the Fourth Amendment that needs to still be obeyed is a warrant has to be specific to the person. You shouldn't have a generalized warrant that applies to all Americans. And so I really object to the bulk collection of data, to saying, hey, Verizon, here's a warrant. We want all of your customers' data. I think it should have to be a warrant for each individual customer at Verizon, not for Verizon as a company to give us all of your records.
Well, I'm glad you brought that up, Senator Paul, because specifically talking about reforms that are coming forward, one of the problems is the Email Communications Privacy Act. It hasn't been updated since 1986. I wasn't even born then. I mean, were you reading emails in 1986? It just seems outdated. What can we do to protect email?
I was in medical school at the time, and we were still passing notes.
Right.
Right. So we didn't quite, email was sort of coming about at the time in the 1980s, but I think my first use of email was probably either late 80s or early 90s. I can't recall exactly, but really you're right, things have changed. But even back then it was sloppy work in the sense that Congress in 1986 was talking about banking records, and even then, you know, my father objected to the records being obtained from your bank, and he was worried about your banking records losing their privacy, but now it's morphed into everything. And this is important because the government maintains, particularly for email, that after 180 days, content or otherwise, it's just been abandoned and anybody can look at it that wants to. But even for stuff less than 180 days, they don't think you have an individual right to your email. They think that they can go to the email company with one warrant and say, we want all of your customers. And this became a real, it's a particular problem, you know, when they went and looked at Snowden's email. I met the person who ran Snowden's company for email, and they're now suing in court over this because the question was, they came to them with a warrant, but it wasn't for Snowden's email. They said, we want all of your email for all of your customers. We want the encryption keys. And this company was specifically set up to have private email. And people say, well, why do you want private email? Why do you not want anybody to read this? Well, it doesn't have to be that you're doing anything bad. You just may want private conversation. That's your own business. But you also may want a private conversation because you're selling your company to someone in Europe, or you may want a private conversation just because it's none of the government's damn business what you're saying in your email. And but because of this, they really played their cards. They think that a warrant can apply to everyone, and this is a big deal. And I really think it needs to go to the Supreme Court. I'm not confident we'll win, but I think that it needs to be addressed at the Supreme Court, and there's a chance that we may win, or at the very least narrow the government's ability to look at our records.
So right now, Senator Paul, there's some legislation going through Congress. I know that you've been a co-sponsor in the Senate of the Electronic Communications Privacy Act reform bill. Can you tell us a little bit more about some of the legislative efforts to sort of deal with I know it's one specific area of this type of privacy, but specific reforms that you're working on right now?
Well, there's a bill that Mike Lee and Patrick Leahy are doing together. And this is an example. There's several evidence of the right and the left coming together. Patrick Leahy, I'd call a progressive from Vermont. Mike Lee, a conservative from Utah, come together and do a bill, and I've signed on to this bill as well. And this would attempt to update the 1986 law to give you protection, to say that after 180 days, guess what? You haven't given up ownership in the email. And because some courts have already upheld this, when you talk to Facebook or Google, they're telling you that they are protecting it already. So if you try to get someone that the government asks after 6 months, my understanding is that both Google and Facebook will send a letter from their attorney back saying, we're not giving it to you without a warrant. And I'm glad they're doing this because they're it's one step up on the protection of privacy that they are doing, even though they're not necessarily required yet by Supreme Court precedent. But we hope to change the law to say that, guess what, your email has not been abandoned after 180 days. I've probably got 4 years of mine on there because I never take the time to go back and delete it. But it's nobody's business what you write in your email. If they want to look at someone's email, it really shouldn't be a warrant given to Google or a warrant given to Facebook. It may have to go to them, but the warrant should have your name on it. It shouldn't say we want all of the emails from Facebook or all of the emails from Google. So these are important questions, and I think we really need to get them out in the open and decide them in front of the Supreme Court.
In terms of the legislative process when it comes to ECPA reform, I've heard that there's some gridlock in actually accomplishing this, even though it's a bipartisan bill, that there are some federal agencies that want special carve-outs so they don't have to have the same Fourth Amendment protections as, say, a private company. Is this an issue you can speak to?
Well, the government is always going to want more power, and they're never going to want to give up any power. They want to be able to have what are called administrative subpoenas instead of judicial warrants. And there's a difference between that. A judicial warrant the judiciary is an independent body. Mm-hmm. The administration, in some ways, are the police because if they have bureaucrats who want information, they are executing a function of the president, of the executive branch. And they actually do literally have police that work for all the different agencies, but really an administrator, a bureaucrat, or a policeman that works for the executive branch should have to go to a judge, which is a separate branch of the government, I think, to get warrants. And there is holdup. But I think this would pass. We have several bills that are sort of right-left continuum coming together that would pass, but they only pass if we get a vote. And so far, we have to get beyond the obstacles. And this is one of my frustrations in Washington, is that even when you have agreement, even when you have 65, maybe 70 senators who will vote for something, you can't get a vote on it sometimes, and it never passes. That's really, truly the dysfunction of this place, is that even when we agree, we can't pass something.
So, Senator Paul, at Generation Opportunity, we're seeking to empower young Americans to really take control of their economic freedom, their future, and their privacy and their well-being. We found that these privacy issues are top of mind for young Americans. I know that you've had a lot of interest from young Americans across the country from all sides of the political equation when you talk to them about a number of issues. Can you maybe speak to why you think these particular issues really drive interest among millennials?
Well, I took the message of respecting and protecting an individual's privacy to their phone records and all records. I took that to the Conservative Political Action Committee group, which is a group of young conservatives. But then I took it about a month later to Berkeley, which is typically known for a more liberal student body. And the same message was received, I think, well in both places. So I think that young people, they're just more interested in this because their lives revolve around their cell phone. They communicate with their friends on a minute-by-minute basis through the cell phone. And they just can't understand why, I just texted my friend a message. But the government gets to look at that message without a warrant. Just by sending a generalized warrant to Verizon, they can look at all of this. And the government will say, oh, no, we're not looking at the content. We're just collecting the content. And to me, that sort of obscures the point, because it isn't really so much whether they're abusing it or even reading the content of emails or phone calls. It is whether they're collecting that and whether or not they think they have the right to collect it. And then some people say, oh, it's just boring old business records, who cares? Well, here's why you should care. 2 Stanford students recently did a study, and they asked 500 people to voluntarily put an app on their phone that recorded just metadata, how long your phone call was and to whom it was. Then they just looked at the data, cross-referenced it with the internet, and said, what can we find out about these people? Well, in 18 people, they said, can we find out their religion? And 15 out of 18, they could determine your religion by how long you talked on the phone and who you talked to. In most everybody, they could tell what doctors you went to, what diseases you had, what medicines you take. These are very personal things that should not be left up to government that can look at. So metadata is important. It's the only thing I object to on the Leahy-Lee bill. When it went to committee, they softened it, and they are going to allow metadata collection. And so it's not going to be perfect. I will probably still vote for it because it's an improvement over the current law. But I would like to see, I think it is important that we restrict metadata collection by the government. And I still think we can go after terrorists, but we just need to go after, terrorists in a targeted fashion and not all Americans' records.
Yeah, that makes sense. Well, I'm glad you brought up that this privacy issue is so bipartisan among young people, because we find that in the nonprofit world, especially as it pertains to young people, we see the same thing. Actually, our co-sponsors at the Digital Fourth Coalition for this event include the American Civil Liberties Union, Heritage Action, Americans for Tax Reform, and the Center for Democracy and Technology. So this is something that I think we really can work together on if we can get past the dysfunction in Washington. But speaking of young people, I wanted to kick it over to one of our Hangout groups. I know we have a question from some of our friends in Wisconsin. We're going to queue them up here and get that done. Wisconsin, what do you have for us?
Hi there, my name is Matt Salmon. Like the rest of us here, we're all from the University of Wisconsin-Milwaukee, home of the Milwaukee Panthers that lost in the first round. Oh well. But anyway, I first of all, I just want to thank you, Senator, for coming out and speaking with us. It's truly an honor, and I really do appreciate that, and I can speak for all of us as well. But the question that I wanted to ask is pertaining to the NSA, as we've been talking about this whole time. What do you think, either legislatively or within the NSA itself, needs to be done to really curtail that power that they have that's been so abused, to where we can trust them again? Does that make sense?
Yeah, I think a lot of it really has to do with how warrants are applied and how we collect things. So I'm part of a bill that is Wyden, Paul, Blumenthal, and Udall. So 3 sort of progressive Democrats and myself, and that is to reform the NSA, to say that when they want to get data, it has to be individualized data, and that we will not allow bulk collection, where one warrant applies to really sometimes literally tens of millions and even hundreds of millions of people's records, that it needs to be individualized. The other thing I would like to see with the NSA, which often works through the FISA court, is that if FISA gives a warrant or a court order and they say to Verizon, we want your records, if Verizon protests that, there's no way for Verizon to get it into a real court. A real court is a public court where you get your lawyer and the other side, and the government has a lawyer, and you get to contest your case. In FISA, you're not allowed to have a lawyer, and it cannot be contested. There's like an appeals process, but it's all within FISA, and it's all secret. I think truth can only be determined in a real court where you have a lawyer on both sides, and then you sort of adjudicate and try to find truth. So our reform would allow court orders that a FISA court order gives to a company, a tech company usually, for that company to appeal it into a regular court. And this is important because the president has said repeatedly, oh, this is no big deal. 15 federal judges have upheld the constitutionality of this program. But what he's not telling you is 15 judges in secret have upheld this court, the constitutionality of this, because they're FISA court judges. And frankly, I don't consider the FISA court to be a real court in the sense that it's not open, it's not public, and you can't have a lawyer. You can't have justice without a lawyer. So our reforms would allow it to go to a regular Article III court in the open, and it would allow standing for people. The other thing they do is that if I go right now and I say to a court, I'm being spied upon, the NSA will say, well, prove it. And I'll say, well, give me my records, and they'll say no. And so it's kind of hard to prove your standing because all of the information is secret. And this is one of the things, while I have mixed feelings about Snowden, I do think that we wouldn't have gotten where we are without the information, because he's released that a photocopy of photocopy. I know that's a really old word. All right, now I'm really dating myself. I'm trying to talk to young people and I'm saying photocopy. But anyway, he released a copy of the court order to Verizon. And so when they try to throw us out of court and say we don't have standing, we can say, well, we've got a picture of the court order. But typically, because these things are secret, they don't. So the other thing we have as a reform is standing. So making it easier for someone to sue and say my privacy has been abrogated, and when the NSA says, well, prove it, and we won't give you any information, it allows us to have an easier chance of bringing our court case.
So my last question, Senator Paul, and I think we're running out of time here. I hear you often say that we need to understand that the Fourth Amendment is as important as the other amendments in our Bill of Rights, certainly as important as the First and Second Amendments and others to our freedoms. Can you maybe talk a little bit about how these rights and our right to privacy, how they fit into our broader perspective?
Well, I think it is important. And a lot of people, if you said, well, should we have a right to a trial by jury, the Sixth Amendment, everybody would say yes, except for the fact that we actually passed a couple of years ago indefinite detention, allowing people to be detained without a trial. So there really are some real questions. And when the president signed that law, he said, but I'm a good man and I won't use this power. It's sort of like, make me a dictator, but I won't use this power. And it's really, to me, not enough. You have to law can't be on the books that could be abused by some other president. I'm not really imputing bad motives or morals to this president. I'm just saying we should never allow any president to have so much power. So this is really not just about the Fourth Amendment and the Sixth Amendment. The idea of records ties into the Second Amendment in the sense that recently in Westchester, a county near New York City, they released all the gun records. And so if you do have a gun, maybe now people know where to come to steal your guns. If you don't have a gun, they know how to break into your house if you're not protected. And you can just imagine a woman who's been abused by a husband and she's fled, and to let someone know where she is, I mean, that's horrific. And so I think really that the constellation of all of our Bill of Rights are being challenged, and really is the overall debate is sort of fear and will we trade our liberty for security? How much are you willing to give up? And if we give up our liberty for our security in the end, who won the battle? If we become more of an authoritarian society and we give up our freedoms, really, what was this big battle we were fighting for? And, when I talk to, there's a young man we know well who lost both legs and one arm in Iraq, and, you ask him what he's fighting for, and he says the Bill of Rights, so it's kind of sad to think about the fact that he gave up so much. He comes home and it's not there.
Well, I think this has been a great discussion. We really appreciate you taking the time to speak to young Americans about issues that they sincerely care about. Do you have anything that you want to say as we close out?
No, but thanks for making me an honorary millennial, I guess, today. So.
Anytime, Senator, anytime. Thank you so much.
We're happy to do that.
All right, thank you.